Yes.
Back is killing me, man.
I see that you're here on 6 different cases. I'm just going to start the recording in a second. I'm going to do this on the record. Okay, we're now on the record. This is the December 15th, 2025, Part 34 calendar. We have 6 cases with the same plaintiff, Terrell Taylor. Those 6 cases are index number 17356 of 24. Defendant is Diane Pollard. We have number 4 on the calendar. Defendant Bronx Honda, CD 19705 of 24. Are those 2 cases related, sir?
No.
No. Okay, we have case number 7 on the calendar. Index 30686 of 24, defendant Premier Physical Medical Medicine and Rehabilitation, PC. We have case 8 on the calendar. Defendant Plaza Honda, index 18480 of 25. We have case number 12 on the calendar, index 15558 of 25, defendant City of New York and the Queens County District Attorney's Office. And we have case number 13 on the calendar, index 15560 of 25, defendant City of New York and the 113th precinct. Okay, I'd like to start with numbers 12 and 13, the cases against the Queens County DA's office and the 113th precinct. Do we have defense counsel with us? Please come up to the table. Yes. Okay. Mr. Taylor, please raise your right hand.
Sir, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
State your name and address for the record.
Terrell Taylor, 174-22, 125th Avenue, Jamaica, New York, 11434.
Thank you. Counsel, you're here for the record. Are you here on both matters?
Yes, ma'am. Good afternoon, Your Honor. The following count is appearing on behalf of the city, last name spelled COUNTS. Again, appearing on behalf of the City of New York, District Attorney's Office of Queens County, and 113th Precinct.
Okay, good afternoon to both of you. I see that both of these cases are scheduled on the Part 11 trial calendar for January 27th, 2026. And Mr. Taylor has filed a request in both cases to expedite that trial date. Is that correct, Mr. Taylor?
Yes, Your Honor.
Okay, I see that also in both cases you attempted to submit this filing by order to show cause, and in both instances it looks like Judge denied your order to show cause, so you proceeded to file a notice of motion. Is that correct? Yes or no?
I don't clearly remember if an order to show cause was filed. That's in the past, but I know there's a notice of motion filed
Okay.
scheduled for today.
The record reflect that pursuant to the court's digital file on, which I'm accessing by NY Bench, it indicates that on 11/7 of 2025, Judge Doshi declined to sign an order to show cause seeking the same relief, indicating that the plaintiff has shown no prejudice or irreparable harm would come by keeping the January 27th court date. The plaintiff then on 12/2 filed the current notice of motion, which is on for today. That is in the case where the 113th precinct is the defendant. In the case where the Queens County District Attorney's Office is the defendant, the order is the same. There was an order to show cause submitted on November 7th, denied for the same reason, no prejudice or irreparable harm shown by Judge Doshi, and then on 12/2, Mr. Taylor filed the current notice of motion. I see both of these cases had previously been sent out for inquest on 10/28, and they were returned to the Part 11 calendar for the trial date of January 27th. Do I have the history correct? To the best
Yes.
of your recollection?
Yes.
Okay, why do you believe that you need an expedited trial date? The trial is set for January 27th. That's about 5 or 6 weeks from today.
Right. So I went before Ernest J. Cavallo on October 28th, 2025 for an inquest hearing on both of these cases, and the defendant didn't appear, which I was under the impression that the defendant is not supposed to appear, but the judge, Ernest J. Cavallo, stated that since the defendant has appeared, that he's transferring the case to room 101 for January 27th, 2026. And what Ernest J. Cavallo describes as an appearance is a telephone call that he put on speaker, and that was an appearance by the defendant. That is not an appearance. So,
Has the defendant filed an answer in this case?
Yes, Your Honor.
When was that answer filed?
I believe August 5th, 2025.
August 5th?
August 5th.
Okay. Do you have a copy of your answers on these 2 cases with you today?
I do.
You do?
Yes, Your Honor.
Okay, I'm gonna ask that you please hand them to the clerk. I don't see them in the electronic file.
Yes, sir. Just 1 second.
Are there the latest answers, clerk?
Even in August, we should have them.
Okay, I do not see answers scanned.
It was followed with the motion paper as exhibit B, so the cover page of the answer will have exhibit.
What motion papers?
I filed opposition to plaintiff's motion.
That was followed with the opposition?
That is correct.
answer? Okay. I don't see it as a separate entry. Okay, Mr. Taylor, I understand that this case was sent to Judge Cavallo for an inquest, and for whatever reason, he chose to adjourn the case back for trial on the part 11 calendar, he is entitled to do that. So again, I will ask you, your motion today is to expedite that trial date to sometime before January 27th. Why do you believe that that is appropriate?
Once again, when I went before Ernest J. Cavallo,
Okay, we're not here to relitigate what happened before Judge Cavallo.
you're asking me,
Cavallo is entitled to return cases to the trial calendar if he feels that they are not ready for inquest. So the question is, you have filed a request for a trial date sooner than January 27th. Why do you need a trial date sooner than January 27th?
are you aware of why the judge adjourned the case and transferred it to a different part? Are you aware of that? Are you aware of why he...
You have not made a motion to revisit that. You have made a motion to expedite the trial.
That's what I'm trying to explain to you, though. So, the case was adjourned to January 27th, 2026, and transferred to a different part. The reasoning, the grounds for doing that, according to Ernest J. Cavallo, is because the defendant appeared. And what Ernest J. Cavallo described as an appearance is a telephone call that he put on speaker. That is not an appearance. But I want to argue something else here because, you know, this motion right here, there's no opposition to this motion right here. And if it is an opposition, it wasn't filed timely.
No, there is an opposition on 12/12, which was Friday, to the motion on the case against the DA's office. And let's see, on number 13, the case against the precinct, I don't have opposition papers.
Say that again?
I don't have opposition papers on the case ending in 560.
Right. My understanding is at the previous conference that I believe was on October 28th, the judge explained to me that both the cases against the Queens District Attorney's Office and the 113th Precinct are traveling together. So my understanding is that they are one and the same case, they just haven't necessarily been,
No, they have two separate index numbers.
I understand that. The judge explained to me, Judge Cavallo explained to me that they're the same matters, they're traveling together, but they haven't been combined.
Yeah, there's been no motion to combine, to combine or to consolidate.
And also, I just wanted to add something. The previous conference that plaintiff is referencing, it was virtual, but I was on a Teams link, it wasn't a phone call, just to clarify that for the record.
Okay.
That's not an in-person appearance. It has to be an in-person appearance. So,
The court, under certain circumstances, allows virtual appearances now.
I wasn't aware of that. Well, this there's no opposition, so you know, can you grant? There's no opposition. You just stated for one of the cases.
Well,
So
here's
that-
the problem. I don't have any dates on the Part 11 calendar until March. So I cannot grant the motion for an expedited hearing. The hearing will have to stay on January 22nd.
All right. So let me
Everybody traveling that day?
So let me get this clear though, because I got two arguments here, you know, one or the other. So, yeah, so an appearance by the defendant can be virtual without me being aware of that.
Any party can request a virtual appearance, yes.
Shouldn't that be a paper trail or some type of, you know, motion or something that has to be filed and served and?
The court allows virtual appearances, that's what I can tell you.
All right. Well, I just want to make.
The only relief that your motion is seeking is to expedite the January 27th date, and I cannot do that.
I just want to make for the record that there was a non-appearance at the inquest hearing on October 28th, 2025.
Cavallo allowed the appearance
Right.
via Microsoft Teams.
Shouldn't his decision after inquest be stamped, showing that it was filed with the court? Both decisions is not stamped. It was never filed with the court, so it's not even enforceable.
Decision and order says after conference with the attorney for the city of New York, the court returns this action to the trial part 101 on January 17th. January 27th, 2026, 9:30 a.m. over the objection of the plaintiff. Higher courts than this have ruled that matters should be determined on their merits. And the case was returned. So, can you print me out the caption sheets for 12 and 13? I'm just going to do an order denying the motion to expedite the trials on these cases will be January 27th, 2026.
Did you hear what I said, or I said that the decision after inquest by Judge Ernest J. Cavallo is not stamped and filed with the court. As a result, it's not
Signed and stamped with the judge's name. If you want to attack that decision, you would have to appeal.
Well, so this is a question for you. Should the decision after inquest, must it be filed? Must it be stamped, filed, and received, or filed with the court? It states filed. Like, I'm not saying his name stamped on the decision after inquest is not adequate. It should be filed with the clerk's office, or it says filed, or whatever it states on the stamp. It doesn't.
If that's the case, what relief are you seeking from that?
Because that if a decision is not stamped and filed with the court, it's not enforceable. It has to be stamped.
Then the case would still be in ready for trial status, and you would have a trial January 27th.
No, enforceable mean it can't be enforced. I know what enforce mean. That means this decision after inquest is null and void. It can't be enforced. So we.
Null and void, then your case would return to the trial calendar and be given a date.
An earlier date. It wouldn't be January.
January 27th is the first day that can get.
Well, actually, that means that I should still have an inquest hearing. Technically.
No, the case
Why would?
was set for trial on this.
Yeah, that's the decision in order. It's not enforceable. The decision in order is not enforceable. So why is the case being transferred to room 101? It should stay in the inquest part.
Make an appeal to the appellate term.
An appeal? So you have a decision after inquest before you that's not stamped and filed with the court. And you
Decision denying your motion to expedite these two cases for trial, you are free to appeal that decision.
in regards to the
Action 40,
We're done,
Your Honor, in regards to no opposition, you're gonna overlook that too? There's no opposition to these motions.
I've heard the arguments of both sides and I've read your papers.
Okay.
Can you print the captions for the rest of those two? Okay. Plaintiff's motion to expedite the trial of this matter from January 27, 2026 is denied as plaintiff has not set forth any emergency or prejudice to the plaintiff. This matter shall proceed to trial in part 11 on January 27, 2026. This is the same order for both of the cases involving the city.
Quick question, Your Honor.
Yes.
Is there a parent? Is the defendant a parent on both cases? Because it looks like there's a non-appearance for the Queens County District Attorney's Office.
Attorney is appearing on both cases.
But you just stated that it wasn't no consolidation for both index.
Wait for your
I don't know. You provided me with a written decision for both.
I am providing you with a written decision for both for the scan, and they will be handed to you. Let's go next to Plaza Honda. jury trial. And that date is May 13th of 2026, and you are now asking to expedite that date. You stated that you believe that the delay is unreasonable and unfair. How are you prejudiced by not having your trial until May 13th in this matter?
Because it's a 7-month adjournment. What this
Court
went.
calendars are overloaded, and the adjournment dates are the adjournment dates. We can't overload the calendars any more than they are. You were given the earliest available date.
7 month. Just for the record, this case went before Soma S side October 1st, 2025.
Yes.
She adjourned it to May 13th, 2026. That's a 7-month adjournment. That's unreasonable, unfair. It's complete bias to me. But secondly, there's no opposition to this motion. So you have to grant it.
There is opposition.
I've never received no opposition. Can I see a copy of it, please?
We served opposition on December 8th.
Do you see opposition, Your Honor?
I have it right here on my computer.
Can I get a copy of?
Stamped by special
Mr. Garland,
card.
please hand it. Do you have an extra copy?
This is, I wrote on it, but this is a copy.
Okay, no, just, we'll print it from the opposition to the motion in the Plaza Honda case, that's number 8.
When was the opposition filed?
Opposition, according to this, was filed on December 9th.
And we served it on December 8th. I have an affirmation of service to that effect as well.
The opposition must be filed 7 days prior to the hearing date.
Either way, your motion papers do not make out a sufficient basis to move up the adjournment date, so the motion is going to be denied. And
So question, even if there's no basis to my argument, if the defendant doesn't oppose it,
even if they don't oppose it, the court still reviews your papers to determine whether there is a valid basis for the relief you requested.
okay, no problem. So a 7-month adjournment is not unreasonable. Okay. Next case.
We have number 8 yet, and I'm not trying to rush you, but we have 3 more to get to, and we have 10
You
minutes.
want this opposition as well, printed out?
Yeah, give them a copy of the opposition.
Okay, fill it out. Okay. Sign it, fill it out.
Okay, this is number 8. And calendar. Okay. Can you get this back to, the next one we're going to do is, Alexander, is that also you?
That is not me.
That is not you.
Excuse me, Your Honor, I haven't received any written decisions for the last 2 cases. This one and the one prior. I'm waiting, like, I need the written decision, please.
You're going to be getting That's the opposition on that motion? Opposition on
Yeah.
talking about index number 84825. Now I'm in
Well, just, keep that, that's it, Alright, this one, we're gonna tell. He's getting out. That one, part one? Okay, that one.
Excuse me, 1 minute.
Yeah, whatever, just like you do. No, I'm just waiting on this. No, it's gotta be this like, yeah, take care of that thing.
The situation in the record on number 4, the defendant, Ron Thomas, scheduled to trial on April 22nd, was the same as the previous one. We're just looking to move up.
Yeah, same issue. This is a 7-month adjournment. It's unreasonable, unfair, and causes an unnecessary delay. Dispute's supposed to be resolved, soon as possible, not 6-month delay. You know better than that, but we could move on. You could deny this too, because 7-month adjournments, like, you gotta be kidding me, man.
Number 4, then we're gonna go to number 7, then we're gonna come back to number 3.
Your Honor, please record, may I be heard briefly?
So that getting into the microphone, very, 1 finger width.
Sorry,
from
this
the
one's
microphone.
on. May I be heard briefly?
Okay,
I filed with the court a notice to change my address,
I have.
because Bronxtown is closed, and I attempted to give it to the plaintiff and he refused.
Okay, you have a copy now?
I do.
You can give it to the plaintiff now.
Thank you, Your Honor.
Okay, that
I got it,
informs you of the new address.
I'm not accepting it. I'm not accepting it.
Well, you've been given it. And if you have further correspondence, it will need to be sent to the correct address.
Your Honor,
Yes.
I have 2 decisions in order. This is an unrelated matter, but I don't know why I have 2 decisions in order right here. Yeah, I don't want it to be a mix-up.
Because they're 2 separate cases.
No, this is the same case.
Let me see. Number 8.
Alright, let me backtrack.
Oh,
Let me take a step back.
Okay, you can give Mr. Taylor back this one.
Alright, you might as well trash that one, right, or is that the one that's,
No, that's the
that's the correct one?
Yes.
Whatever one is,
Here is this.
you give that back, that's the correct one. 1558. And 1556, those are 2 correct ones.
This is the incorrect one.
So from number 8.
Right.
Yep.
And again, on number 4, Bronx Honda as defendant. Is there any new argument, Mr. Taylor, or is it the same situation? I understand your frustration after all the adjournment. Those are the dates.
Yeah, that's my only argument. I also want to make the court aware that this paper that the defendant just handed me regarding the change of address, it says defendant Bronx Honda has been closed since July 28th, 2025. I just received mail from Bronx Honda like a couple days ago, same address, 2541 East Tremont Ave, Bronx, New York, 10461. So if it's closed and the dealer is operating at a different location, or why am I still receiving mail?
The attorney's address, not the dealer's address. They're represented.
There's a, if I may, Your Honor, there is a new Honda dealership operating at that location. They might have sent him an advertisement. Nobody sent him anything regarding this case.
All right, question, what would be the purpose of the defendant informing me of the change of address?
That's the defendant's attorney informing you of their change of address, so that any papers you may serve in this action going forward, you'll have the correct address to serve them on the attorney for the defendant.
And that address is 1771 Post Road East, 130 Westport,
Yes, sir.
right? Okay, and that's the attorney's address.
That's the attorney's address. Yes,
Right.
when a litigant is represented, any communication with them about the case must go through the attorney.
Got you.
Directly to the litigant. Do you understand?
So as far as the dealership not being at that location and the attorney's address, those are two different things, right?
Those are two
Two separate.
Now, your case may be impacted by the fact that the dealership is now under a new name or a new owner. I can't advise you how that might impact your case, but I can just tell you it might impact your case.
Well, it doesn't sound logical, so can you give me some sort of explanation? How would that affect my case?
I would recommend speaking to an attorney.
No explanation, right? Okay, cool.
Do I have
There's no opposition to this motion as well.
again, before I make a decision based on the papers?
No problem.
Honda, this is number 4. So your trial is going to be in court 8 on April 22nd. 26th.
Written decision, right?
Say that?
Written decision?
Yep.
Thanks.
Okay, here is the Bronx Honda one sign. Okay, you can have stipulate for your copy of this. We'll be prepared for trial on April 22nd. Next, we're going to have Premier Physical Medicine.
Yes, Your Honor.
Can you please place what you're on the record?
Michael Pinta of Ruben Catamiti, Gonzalez, Rizzo, Kaufman, address 200 Garden City Plaza, Suite 400, Garden City, New York, 11530. Attorneys for the defendant, Premier Physical Medicine and Rehabilitation, PC.
Okay, thank you. For the record, this is number 7 on the part 34 calendar, next number 3066624, correct error, against Premier Physical Medicine,
Same argument, but this is a 9-month adjournment this time. It's not a 7-month. This is a 9-month adjournment, which is significant delay, unreasonable, and the adjournment was for no legitimate reason. I appeared in court before Honor Ira R. Greenberg for a jury trial, and the case was adjourned to November 12th, 2025.
You can get a sooner date
I mean,
for a bench trial than you can for a jury trial. You understand that? If you
I mean-
want a bench trial, I can give you a sooner date. But if you want a jury trial, I cannot give you a sooner date. That's up to you.
well, if I knew who it was going before, then I would probably.
You don't get to choose which judge you issue.
Right. I complained against you like 5 times already, and I'm still coming before you. So I definitely wouldn't want to have a bench trial before you. I filed a complaint with the Commission on Judicial Misconduct, actually for a case that you just was presiding over a couple days ago. So I have like 5-6 complaints against you. So it's important that I know what judge I'm going before. But no opposition for this motion. It's a 9-month adjournment for no legitimate reason. Do you have a decision in order? There was no written decision regarding the reason for the adjournment. So you have no written decision.
Don't require a written decision. Anything else?
You say that again?
I said adjournments do not require a written decision. Do you have anything else to argue on this case?
So can you explain to me why was there an adjournment? I'm not even talking about I'm not talking about the delay. I'm not talking about the time frame. I want to know what was.
I don't know why he adjourned it. All I know is that he adjourned it last time.
Your Honor, if I may interrupt briefly.
Without a written decision? So you have nothing in the file that explains the adjournment, why there was an adjournment. And you're not going to look into that? You're not going to look into why there's a 9-month adjournment with no written decision?
Correct.
Okay, no problem.
So your motion is to have the trial remain on August 3rd, 2026. Do I have the last one? Okay, the last one up will be number 3.
I just have to going down now.
Dan Pollard.
Miss, keep giving me this. Let's throw that away. This is the one that he told you to throw away last time. You gave it back to me again. So you run a question for you because we're waiting, right?
Give me 1 second, please.
All right.
So this one, we're waiting for the attorney.
Right. Can I ask a quick question then? So I don't know if this.
Can't be about this specific case. If it is
No.
about this particular case against Diane Pollard, then I'll need you to wait for the attorney. If
No, it's about the case that.
more in general, then you can ask.
Right. So if I'm explaining to the court that my case was adjourned for no legitimate reason, and then there's nothing in the file that explains why it was adjourned, and the adjournment is a lengthy delay, you're not gonna do anything about that? You're not gonna look into that or any?
I can tell you that we definitely could use more judges in this courthouse and more staff so that people get trials sooner. Unfortunately, we don't have control over that, so the adjournment dates are what we want.
Let me repeat that because maybe you didn't understand what I said. I'm speaking about the length of the delay, but I'm also telling you that the adjournment was unreasonable and there's nothing in the file explaining why there was an adjournment.
There does
So-
not have to be a written order when a
Does it have to be anything that explains the reason for the adjournment?
There's the new date into the computer. There's no written order on an adjournment.
Right. I had to ask again because I find that to be really odd that I could come to court, let you know that I feel that this adjournment is lengthy. That's just how I feel. I feel that it's unreasonable. But most importantly, there's nothing in the file explaining why this case was adjourned, and you're not gonna do anything about that. Cool. No problem.
I can tell you that there are other kinds of cases in this courthouse that currently have adjournment dates into March of 2027 for a trial. You're actually getting a significantly better date than they are.
That doesn't mean that it's right though.
I understand your frustration.
Just because y'all violate people rights get violated all the time. So if you're telling me this was done to one, plaintiff, it doesn't mean it's right. It doesn't mean that it's okay to do it to me.
Share your frustration, sir.
Right. The courts is here to resolve disputes smoothly, swiftly, in a timely fashion. And you know that. And a 7-month adjournment or a 9-month adjournment is very unreasonable, and it's biased toward the party who's toward me, actually, the plaintiff.
I do understand your frustration.
No problem.
The court is going to note that we don't have the attorney, because I am calling present. They did check in, went to another part. The court notes that on September 24th, 2025, the pastor denied a request for the relief now being requested by Mr. Taylor, who has made a motion. Then September 24th, the request for an expedited trial was denied. And likewise today, the request is going to be denied. The trial is scheduled for part 8.
What case is this, Your Honor?
This is Diane Pollard.
That I don't have that same argument for this case right here. This is a different argument.
Okay, please give me your argument for this case.
Okay.
Trial is scheduled for May 11th.
Exactly. I feel like that's unreasonable as well, but there's different. There's more to the There's more here. So on October 23rd, 2025, order to show cause went before Honor Amish R. Doshi regarding the expedited court date for jury trial, which was initially scheduled for May 11th, 2026. So on October 23rd, 2025, Honor Amish R. Doshi marked the case as fully submitted and stated that a written decision will follow. It's been more than 30 days since the case has been fully submitted, and I have yet to receive a written decision.
That was defendant's motion to dismiss.
Huh?
That was, let's see, I have defendant's motion to dismiss that was submitted. I have an order to show cause that was signed by Judge Lane requesting this relief. Judge Doshi still has yet to make a decision. This refers to the same May 11th date. So actually for this one, there is another motion still outstanding for the same relief that you're requesting today.
There's an outstanding motion.
Yes, your order to show cause from, it looks like August 8th, requested advancement of the trial date, and that is one of the motions that is currently with Judge Doshi for decision. Is that correct?
Yes, order to show cause, yes.
Okay, so this motion you've made here is for the same relief. I can't decide this motion for the same relief, but can you print me out another caption without the body text on the Diane Pollard?
What I'm stating, Your Honor, is that initially I was arguing that the court date should be expedited because it was scheduled for May 11th, 2026. But in this motion right here, I'm stating that the judge didn't make a decision, and it's been over 30 days since the case was fully submitted.
The judge has 60 days.
They have 60 days?
Yes.
So when does a judge have 30 days to decide?
The judge has 30 days to decide in matrimonial matters seeking temporary support.
So when there's an order to show cause filed or a notice of motion filed with the court and it's fully submitted,
Yes?
the judge don't have 30 days? I thought it was 60 days just for a bench trial or something like that. But when we talking about motions, it's less time. They don't have the same amount of
It's the same 60 days.
the same 60 days? Okay.
Okay.
Was there opposition filed to this? I guess it was. Yeah, it was. Your Honor,
The date of that motion was 10/23/25.
Your Honor, the court notice that I received,
My order on this one is gonna read that plaintiff's motion seeking an expedited trial date is denied, as there is a currently outstanding motion for the same relief that was submitted to the court on October 23rd, 2025. Can we scan that and give everyone copies? I believe that concludes the calendar, Cliff.
Your Honor, was there a written decision for Premier Physical Medicine and Rehabilitation? I haven't received that.
You'll be getting a copy of that from the clerk momentarily.
Okay, we got it. I'll get up. It's after 1. I'm supposed to lock the door, 1 o'clock. Mr. Taylor,
You're giving me the same papers over and over.
listen, I gotta lock the door, I'm sorry. I'm very late.
Mr. Taylor,
Yes.
which ones do you not have a copy of?
I believe I have a copy of all of them.
You have Pollard, you have, Premier?
Yes.
Okay, we'll see you on the trial dates. I wish you luck.
Me.
Mr. Taylor, I gotta lock the door.
Off the record.